by 34 members. Meaning, I'm sorry. My lord, meaning thereby, as on this date, my lord, that is 21st of June 22, the Honorable Governor was informed that there is no change in the leader of the legislature party, and Sri Eknath Shinde continues to be the leader of legislature party in Maharashtra legislature. Lord, thereafter, I'm sorry, my lord, can I proceed? My lord, kindly come to PDF page 21.
This resolution is also of the 21st, no?
21st, my lord, yes. Later sent to the Honorable Speaker and the Honorable Governor on the same day, informing that any unauthorized meeting where 14-15 MLAs may have gathered to change the leader is unauthorized, and Sri Shinde, who was appointed in 2019, continues, and all 34 have signed. Now, my lord, page 21.
Page
31. I'm 21. On 25th of June 22, Lord, I'll not approximately, exact, I'll give the figure. Lord, 38 MLAs, it contains signature of 38 MLAs, writes to the Honorable Governor that malicious withdrawal of security of our family members have taken place. And there they point out certain, Lord, shocking facts, and also produced before the governor the video clips of national news channels which your lordships would find at PDF page 22, para 5 bottom. Lord, one leader of the Lord, the party says, let all the MLAs come to the floor of the house. We'll see then these MLAs who have left, they will find it difficult to return and move around in Maharashtra. Then, my lord, the NDTV clip is produced. Then, my lord, these are the signatures of. I'm sorry, my lord. There are. I'm sorry, my lord. I stand corrected. My learned friend is right. There are not only 38 MLAs, 38 MLAs belonging to Shiv Sena, and at page 27, they are independent. My lord, there is some other party, small party, my lord, Prahar Janshakti Party. They have 2. So, meaning thereby, my lord, 40 and 7 independent. So, 47 members of the House, 38, 2 and 7, inform the governor about the threat being administered.
MLAs, just give us again.
Yes, my lord. Kindly, my lord, come to page
38 Shiv Sena.
Yes, no, 38 Shiv Sena. Yes, lordships are right, no? 38
party.
Lord, that your lordships would find the last figure at page 26, PDF 26, 38 Shiv Sena.
Right.
Then at page 27, Prahar Janshakti Party Amdar. Amdar would mean member of legislative assembly. Amdar and Khasdar. Khasdar means
to
Member of
MLAs.
Parliament. My Lord, the Chief Justice would be obviously knowing. Then, my Lord, page 28. These are Apaksha Amdar. So, independent members. They are 7. So, total 47 members. Pointing out that threats are being administered. So, thereafter, at page 29, the Honorable Governor informs the central government as well as the state government that this is the representation which I have received, and therefore he requested. Lord, kindly see page 29. Lord, the letter addressed to the Home Secretary of the of country, my Lord. Unnumbered middle para, my Lord. That would be relevant. Your Lordship has that, my Lord. Your Lordship, may I read? Second unnumbered paragraph. I have already issued directions to the state police to provide adequate police protection to the MLAs, their families and homes on an immediate basis. Now, please see, despite this, offices and homes of some of the MLAs have been vandalized, with the police being a mute spectator. It is accordingly requested that adequate provision of central security forces be made and kept ready in case required to address the situation. Lord, next page 29, page 30 is a similar letter to the Chief Secretary of the State of Maharashtra. Lord, kindly see the second unnumbered paragraph. I therefore direct you to provide adequate police protection to the MLAs, their families and homes on an immediate basis. Lord, similar letter I'm not reading at page 31 to Additional Chief Secretary, State of Maharashtra Home Department, that you provide immediate security. Lord, a similar letter at page 32, PDF page 32, addressed to the Director General of Police, State of Maharashtra. Same, Lord, direction that you provide immediate security. I'm not reading it, my lords. Lord, next is, my lord, page 33, similar letter to the Police Commissioner, Mumbai. Now, my lord, comes page 34. Bharatiya Janata Party, Maharashtra Vidhi Mandal Paksh, means legislature party of Bharatiya Janata Party, writes a letter dated 28th of June 22. Lord, kindly, my lord, allow me to place this, my lord. This was not read, my lord, by. Lord, this is signed by the leader of the legislature party, Shri Devendra Fadnavis, in the House on behalf of the party, and there is no dispute that he is the leader of the House so far as this party is concerned. I am elected, your lordships can skip first, the election to the Maharashtra am I with your lordships at page
Yes, yes.
34. The elections to the Maharashtra Legislative Assembly was held on 21st October and the result were declared. Well, then he gives the bifurcation, your lordships have taken note. Shiv Sena had contested the election in pre-poll alliance with the BJP. However, after declaration of results, the Shiv Sena chose to enter into a post-poll alliance with NCP and INC to form Mahavikas Agadi government. The BJP is thus the principal opposition party in Maharashtra Assembly, having 106 members. It appears that over the last 8 to 9 days, there has been an internal strife within the Shiv Sena legislature party. It is common knowledge through widespread media coverage that a majority of Shiv Sena legislature party is feeling that their party's ideology is compromised. It is reliably learned that Shiv Sena legislature party and its leader have clearly indicated to the Chief Minister Sri Thackeray and that they want to end the alliance with NCP and INC. The Chief Minister has thus lost majority in the assembly. My belief that the Chief Minister Sri Thackeray has lost the majority in the Vidhan Sabha is further reinforced by various news reports circulating in electronic as well as social media, where a group of 39 MLAs of Shiv Sena are seen declaring that they want to exit the unnatural alliance with NCP and INC. The chain of circumstances and events has envisaged in the electronic media and various statements made by the majority group of 39 MLAs, it make it sufficiently clear that Sri Thackeray does not enjoy the majority of the floor of the Vidhan Sabha. I say and submit that there is a wide coverage in the electronic media about the members of Shiv Sena legislature party being threatened by their top leadership, and there have been incidents of attacks on the residences and offices of such members. Further, there appears to be the provocative statements made by the leaders close to the Honorable Chief Minister to incite violence against the members of Shiv Sena legislature party. I submit that the same is being used to browbeat and coerce the aforesaid members to fall in line and to make up for the lost majority of the Chief Minister. I submit that the violence unleashed against the members of Shiv Sena legislature party is at the behest of leaders close to the Honorable Chief Minister. For instance, Shiv Sena Melava in Bombay, some rally or a gathering, Sri so-and-so issued a disturbing threat saying, and my lord, video is attached for the governor to see, which the governor has seen. 40 bodies will arrive from Guwahati and they will be directly sent for postmortem. Lord, this is not denied or disputed on facts before your lordships or before earlier. So Governor, my lord, relied upon it. That's all, my lord, I'm saying. Another instance of a clear threat by Sri so-and-so is where in an interview given to a leading channel, he has clearly stated that the ongoing violence is only a warm-up and that the trailer will come later. He has further stated in the said interview that stones will be pelted at the MLAs. The said interview can be accessed and the link is given. No, it's not just ipsi dixit or not some personal view of any particular individual. Then, my lord, he gives several other links for the governor to see. Lord, this was the material before the governor. Now, my lord, please come to page 38. Lord, this is I'm sorry, this is, my lord, attached. This is the, my lord, attachment to the email, my lord. Your lordships may skip that. Then, my lord, next is later dated 28th of June 22. My lord, this has been read and reread, and therefore, my lord, I am not reading it substantially. I'm sorry, my lord, this is not read, my lord. I'm sorry.
What is 38? 38? 37 or 38? That later.
My lord, 38.
Attachment. What is that attachment?
Yes, my lord. I'll just letter of independent MLAs to the governor. I'm sorry, my lord. My lord, the attachment is at next page, my lord.
Please read. What is it?
Yes, allow me to read, my lord. This was not placed by my colleagues, my lord. Request to, this is by the independent MLAs. 7 independent MLAs.
Those who earlier supported.
Yes, the very same MLAs. They say, request to ask the Honorable Chief Minister to prove the majority in the shortest possible time. We are members of so-and-so. Your lordships can skip, my lord, the statistics. Para 4. However, in past few days, it has become crystal clear that Sri Thackeray, Chief Minister, Honorable Chief Minister, does not have a majority in the Assembly. The same was reflected in the recently concluded elections for Rajya Sabha members as well as the elections for seats of Maharashtra Legislative Assembly. Well, this is also another material that he couldn't, my lord, get the people of his, my lord, party elected. The dwindling majority of the incumbent MVA government has been further reduced when more than 38 MLAs of Shiv Sena who were earlier supporting the Honorable Chief Minister, declared in press as well as social media that they want Shiv Sena to break its unnatural alliance with NCP and INC. Various photographs and videos have been in circulation in the media of Shiv Sena MLAs reaffirming the said claim. The turmoil within the Shiv Sena legislature party and Shiv Sena has raised serious doubts about the Honorable Chief Minister Sri Thackeray commanding the support of the majority of members in Maharashtra Legislative Assembly. In short, the events that have unfolded in the past few days in the state of Maharashtra have made it absolutely clear that the current incumbent MBA government led by the Honorable Chief Minister no longer enjoys the majority in the assembly and therefore does not have any moral, legal, constitutional or democratic right to continue as the Chief Minister of Maharashtra. We have also come to know that Sri Thackeray and his colleagues, with a view to convert the minority into majority, are trying to get certain MLAs of Shiv Sena disqualified by misusing and violating the provisions of anti-defection law. We have already addressed a communication in this regard with our letter dated 24th June to the Deputy Speaker, copy whereof is attached herewith. Your Excellency will agree that in a democratic setup, only a person who enjoys the majority support of the House has a right to continue as the Chief Minister. A person who does not enjoy such majority has no right to continue as the Chief Minister and is obliged to prove his majority on the floor. In view of the matter and keeping in view the established democratic principles, my Lord, they seek that immediate floor test be directed. My Lord, now your Lordships have read this letter, my Lord, which is at PDF page 42. This, my Lord, is read and reread, whereby the Honorable Governor requests the then Honorable Chief Minister, Sri Thackeray, to prove his majority, my Lord. I am not reading it, but, my Lord, kindly see, my Lord, the request, my Lord, is a special session, my Lord. This is at page 45. Therefore, I'm just showing, my Lord, that this was exercise of powers under Article 174, read with 175 too. Therefore, in keeping with the constitutional and democratic values and principles as also the law laid down by the Honorable Supreme Court of India, and in pursuance of the powers conferred under Article 174, read with Article 175(2) of the Constitution, I hereby issue the following directions. A special sessions of Maharashtra Assembly be summoned on 30th June at 11 a.m. and, my Lord, other consequential directions. Lord, suffice to say, your Lordships have seen, the Honorable Governor relies upon Bomai, Rameshwar Prasad, Shivraj Singh Chauhan, etc., my Lord, that floor test is the only test. And the only satisfaction which the governor is supposed to reach at this stage is the satisfaction that floor test is required. He is not supposed to Lord, record a satisfaction that yes, you have lost majority. He doesn't do that.
But he does that. He does that. Governor says, I'm therefore confident that you and your government has lost the trust of the House.
Lord, for the purpose of yes, Lord, for the purpose of he is justifying his direction that now you go and prove it otherwise. That no, you have the trust of the House. Lord, otherwise he would have invited somebody else immediately, my Lord, if he would have arrived at that satisfaction, which he could never have arrived at constitutionally. It has to be the satisfaction to call for the floor test. That you go and face the test. This is prima facie material. Material is unimpeachable. Everything is in public domain. The elected people are coming and representing to me in writing. Go and Lord, face the floor test. Yes. Yes. Lord, now if that satisfaction is not recorded, that there is a
so really speaking, Mr. Solicitor, the material before the governor was only three things. One, the resolution by 34 MLAs that any change in the leadership of the House is not warranted, that therefore they continue to have reaffirmed that the leadership will be with Eknath Shinde, not with Chaudhary or Gogaule. One. Two, the letters by 47 MLAs about the threat to their security.
For converting minority into majority.
And the third, the letter of the leader of the opposition.
Yes.
that 39 MLAs of the Shiv Sena want to exit the alliance with the BJP, with the INC and the NCP.
Yes, my lord. And saying
Essentially, all this correspondence boils down to three aspects, three things basically. Independent MLAs,
and
the leader of the
resolutions
opposition,
passed,
and the 34 MLAs.
resolutions passed by them respectively, letter is accompanied by resolutions to show that this is not happening for any other reason. This is happening because the chief minister has lost majority and he wants to convert his minority. That's the only thing, my lord, in my respectful submission, the governor is supposed to see. That in fact, he appears to have been reduced into minority, but he can go to the floor of the house. That's the ultimate.
Ultimately, it boils down to this. Suppose there is a policy difference between a group of MLAs within a party.
Yes.
Here it was on the alliance with the NCP and the INC. Suppose there's a policy difference on whatever aspect, spending funds for a backward region in the state. We don't want this to be done.
Several, yes, sir.
The difference of the MLAs can be on a variety of things. There's a policy difference of a group of MLAs within a party, because governor also says they also don't say that look, we are leaving the party, because the moment they say, because governor also says they also don't say that look, we are leaving the party, because the moment they say that they are incur the 10th schedule. Can the governor merely on that basis say, now I'm of the view that you must prove your trust vote in the, you must go to a floor test.
I'll answer that, my lord. But that, my lord, I would better answer after showing the law on the point, because my lord, the answer is this, immediate answer is this. The reasons for the dissatisfaction or reasons based upon which the sitting chief minister has lost majority is not the consideration for the governor. That can be a ground for disqualifying them, taking any other action within the party fold, etc. The governor is supposed to only understand, no, my lord, and that's what the law, your lordships have laid down, whether he has lost majority support or not. Whether
two different things, you see. One is whether the governor has material to indicate that, well, that the existing government has lost majority on the floor of the house. Equally, the governor must be conscious of the fact that his very calling for a trust vote may lead to a precipitate loss of majority for the government, because calling for a trust vote may itself be a circumstance which will lead to the toppling of the government.
My lord, I don't think, my lord, with profound respect, my lord, as I understand, the governor, my lord, cannot take that call.
Governors should not really lend their office for effectuating a particular result.
Lord, kindly see, my lord, kindly examine it.
Here you have a leader of the opposition writes. Leader of the opposition.
The difficulty is, my lord, my other
leader of the opposition's letter is irrelevant, according to me. The leader of the opposition will always write to the governor. They, look, these people are acting contrary to the constitution, that their policies are anti-people. That is no ground for the governor to act. The independent MLAs who said, or the MLAs who said, my security is under threat, this was not a report under Article 356. He was not saying that the government of the state cannot be carried on in accordance with the dictates of the
That's going to be my submission, my lord.
So the threat to security cannot be a ground for calling for a trust vote. So both those are out of reckoning. The only thing which survives is the impact of the 34. Because
may I answer that? May I answer
34 that? Is something which is because 34 in a party which has 55 MLAs. So
Lord, may I answer that? Lord, first of all, the parameters for Article 356 are different, and 174 is
what the governor's letter may indicate is that he was of the view that there was a certain dissension within the party on whether to continue with the alliance with the Indian National Congress and the NCP, right? Can that be a ground for the governor to say you call for a trust vote?
Thank you, Manoj. And allow me to answer. The governor.
Then you are virtually breaking a party.
Manoj, the difficulty is, Manoj, I'm answering this question before my legal submissions are over, because most of your lordship's questions can only be answered from my legal submissions, which are yet to follow. But my immediate answer is this.
You see, looking at it in hindsight, in hindsight, they had lost the mathematical equation. They had lost. It was very obvious that when 34, and that's why, as Mr. Jetnalani said yesterday, They were not willing to disqualify all the 39 because they also realized the moment you disqualify 39, then it redounds to their disadvantage. So they were trying to disqualify the 16 so that you give a threat to the other 23 that look, you will also suffer the same fate. All right. They also knew that they were likely to lose the plot, but we are now on the governor's powers. We're not so much on the mathematics. And okay, now at the end of it, it's very obvious that they had lost the numbers game. But equally, what is a very serious concern is that governor should not enter into this any area by which their action will in fact precipitate the fall of a government.
That is where I would very earnestly and respectfully, my lord, differ constitutionally, and I'll answer that.
Stand away and say that, look.
Can I, before your lordship, my lord, concludes on this point, would your lordship, my lord, allow me to narrate, my lord, place the law on the point? Because law, as I have understood, my lord, subject to your lordship's final approval, may not, my lord, support this conclusion. My lord, if there is a dissatisfaction, the governor's responsibility is to ensure that the stable government is there and government functions in a stable way. If somebody goes and says that there is a party dissatisfaction inter se, may not be a ground for the governor, my lord, possibly to call for a trust vote.
Suppose there's a political party.
My lord, if your lordship,
MLAs of a political party feel that our leader is not true to our ideology, that our leader is not carrying out the basic ideological premise of our party. Take it. Forget Uddhav Thackeray, forget Shiv Sena for a moment. They have their remedies. They can always say that we'll vote our leader out. We believe that our leader does not pursue the ethos of our party. They can always vote the leader out in a party forum. But can the governor say that because there is a dissension about a certain aspect of the leadership, therefore I'll ask them to now prove that it's a government which has been formed. It is a government which has established its majority on the floor of the House. It's a government which is a functioning government. And these and we are now not at the inception where you have to ask for a trust vote. I'm not saying that there is an absence of power on the governor. There is, of course, there's a power in the governor even after a government is formed, because a variety of things may happen which will lead the governor to say, no, prove your trust on the floor of the House. But what is really the problem here is that governors, in exercising that power, may actually precipitate the fall of the government. And that is something which is very, very serious for our democracy.
May I answer, my lord? Okay, I'm running against time, but your lordship would accommodate me, my lord, obviously. I'm on the first point right now. One.
And this is irrespective of their numbers. There's no doubt about it that they lost the numbers at that point of time. But
I'm answering as a proposition of law. Lord, kindly allow me to at least answer, my lord, this. I've understood, my lord, your lordship's concern on the constitutional proposition, which is canvassed, my lord, by a party which has otherwise lost the majority support, as the figure suggests.
And all this hyperbole that you will have 40 corpses and all, Maharashtra, it's not some. It's a very highly cultured, developed state. I mean, things are said in politics. Sometimes things are said which are inappropriate. They should never be said. As we said just the other day, Mr. Mehta, that we said to Dr. Singhvi in a matter where he was appearing that there has to be some level of constitutional discourse and dialogue, which is unfortunately going down in our country. So we are not condoning it. We are not at all condoning it.
Please don't. This amounts to condone.
No, my concern is. No, we are not condoning it. In fact, we have expressed the most serious concern about where it's like, in fact, in one of our orders, just Narasimha and I say it's like a race to the bottom. But that is different. I mean, we're not condoning it at all. We are deeply concerned with it as a constitutional court. But fully, we have to also say that what about the governors? They must exercise these powers with the greatest circumspection and caution.
Would your lordships consider differing this view till, my lord, my...
Okay. We'll see the judgments, of course.
Yes. Lord, kindly allow me to answer at the outset. I'll show the judgments. Lord, whenever the governor's prime responsibility is that a stable government continues, number one. Kindly allow me to complete. Number two, The democratically elected leader should not only enjoy the confidence of the House when the government is formed, he should continue to enjoy the confidence of the House throughout the tenure. And that's going to be my another limb of submission when I examine the governor's power in facts of the case is concerned. Otherwise, there would not be any accountability on the leader so far as his constituent electorate is concerned. He can say that now I am elected to hell with you. I will not concern. I'm not concerned. Allow me to.
Mr. Solicitor, the monsoon session was coming. This was all happening in the third week of June, the last week of June.
Can I complete?
The monsoon session of the State Legislative Assembly was going to take place when you will place supplementary demands. That's the surest test. If they have to seek the vote of the House on passing legislation, on supplementary demands, one aspect of a revenue measure, and if the government does not get a vote, they're out.
Well, I will show the judgments. Well, the
judgments of the monsoon session, which was going to take place.
Well, I'll have to, my lord, read some judgments also, my lord, and therefore I would earnestly request your lordships to defer this tentative conclusion.
This is not a conclusion at all. This is a concern which we are.
Another thing.
We may eventually accept your submission, and we will equally put your argument to Mr.
No, I understand. I'm fully conscious. I'm confident and
quality. What is happening is
my worry is difficult. My worry is different.
Ultimately, whoever fails, whoever succeeds is a separate issue. But
my worry is different. My worry is different, and I'll put it first. Thereafter, I'll answer that question at the outset and elaborate. But what was said was not just an inappropriate statement which the governor could have ignored. It was a threat that you will be brought dead and sent to postmortem. That the House is being. Please don't condone it. Not even inadvertently.
He wrote to Mr. Limay, who was the additional chief secretary, provide security. He did his duty by providing that. That please provide protection. Your duty.
Permit me, Malad, to. Anyway.
But bringing down government because of some member of the Legislative Assembly saying that, we will,
sorry, my lord, that's too simplistic a way to look at it. Lord, please look at it holistically. 34 MLAs goes that we have lost confidence. They might be disqualified, they may not be disqualified. Whatever is the consequence, forget it for the time being. Along with 2 + 7 other MLAs that this man is not enjoying majority support. Kindly, my lord, allow me to complete. Lord, before your lordship, Lord, expresses the concern. They are not saying that we don't like him or we don't like that, Lord, A, B, C, D reasons, and therefore he has not, he has lost our confidence. Now, my lord, all these allegations, all these threats are being administered, and the governor is supposed to be not a mute spectator because the threats are administered not as a law and order situation. The threats are administered and governor is informed that with a view to create an artificial majority, now not only threats are administered on public platforms, but really attacks are taking place. Lord, would I expect the governor to sit as a mute spectator and say that you wait till your monsoon session? This is your internal dispute. You sort it out internally. The minimum thing, Lord, the Supreme Court has said is that the governor is not only entitled, he is duty bound to hold to direct that if this is the situation, you hold a floor test. If that, my lord, according to their perception, might aggravate the situation for the chief minister, my lord, again, that consequence is not for the governor to keep in mind. If in a democratically elected body like like a legislative assembly, if I am elected as a leader, I should not only inspire confidence at the outset, I should continue to have that confidence throughout my tenure. Otherwise, it results into complete lack of accountability and answerability, which is a facet of democracy, and it would result in complete tyranny. That now I'm elected, you can do nothing to me. Look, that is not what is conceived of the governor's function, because governor comes into picture only in rare situations like this, that for whatever reasons you have lost your confidence. If 34 people have come, maybe because of my floor test, 34 may become 40. I'm taking the extreme example, as your lordships have very rightly expressed the concern that it might aggravate the situation. But That's how the democracy works. That's how, my lord, leadership works. And therefore, my lord, they say that you can inherit leadership. You cannot inherit leadership qualities. And that is where the leadership quality comes into play in a
The only
democracy.
concern, Mr. Mehta, is that what happens is people start ditching a government. And, you ditch your government, and then for a variety of reasons, the governments and the governors are willing allies by saying hold a trust vote. So you give sanctity to this act of.
I am not entering into the area whether they should have or they should not have.
It's very,
That's for them to answer.
This is a very sad spectacle, in our democracy that, you allow.
My lord, I don't, as a governor, I can't answer that question. But otherwise, my lord, if your lordship,
I mean, this is irrespective of the morality of the Shiv Sena having joined with the INC and the.
that was also, my lord, the majority feels was a sad spectacle. My lord, ultimately, all these resolutions say that having gone before the electorate, and my lord, I would like to read, my lord, kindly allow me, my lord. Okay, my lord,
Yes.
kindly allow me. In Kyoto, your lordships very carefully say that when you go before the electorate, you are not going as an individual. You are going as a representative of a particular ideology. You are doing two things. A, I am representing a particular ideology, vote for me. He represents another ideology, don't vote for me. Now the situation before your lordships and before the governor was that majority of me who went with a particular ideology, particular coalition, particular, my lord, joint, my lord, program, sit with him against whom we contested the election, and majority say that this is a spectacle we would not like to be a part of. I'm not concerned as a governor. I'm not concerned as a governor. So that's, my lord.
And but they broke bread for 3 years, no? Exactly. They
Lord,
broke
this is a
bread with the
political
Indian
debate,
National
my lord.
Congress and
Lord, your
the NCP for 3 years.
Lord, your-
What happened overnight after 3 years of a happy marriage?
my lord, please see, my lord, then I'll read, my lord, what is their reason, because it's not my function to answer that. That's a political debate.
The
Or
governor has to ask himself this question.
On lighter side, you can very well say, staying together for 3 years cannot be said to be a happy life by that.
But the governor has to ask himself this question. What were you fellows doing for 3 years?
Lord, governor has
You're not in 1 month after the election has taken place.
Lord, kindly,
I
Lord,
can
kindly come
understand.
to
1
page,
month after the election takes place,
Lord,
the
I have
chief
not,
minister suddenly breaks up with the bypasses the BJP and joins with the INC. And
Lord,
governor can say, sorry,
must,
there's a
Lord,
serious discontent in the party.
Lord,
3 years you cohabit, and then suddenly one fine day, a group of 34 say that there is discontent.
kindly allow me to
They
place
all
what,
went and became ministers.
Lord, the difficulty is, my lord, out of, my lord,
Enjoying the spoils of office, and then suddenly, one day you just
wake up to the fact that
I leave it to your lordship. Well, that's a political debate, but I have an answer. If your lordship allows me, I'll answer.
You can go to the law council.
now tell us, show us the law now.
I will.
You
But
take
before
us to
that,
the
let
law
me
first,
answer.
then
Let me
thereafter
answer.
apply the later.
Well, let,
Please do one thing. You can show the law, correct? Power of the governor, what can be waged with the government, and thereafter you take it to take us to the later, that whether it fits in that law or not.
my lord, kindly, my lord, note here at this page,
Yes.
14 is the answer. I'll come to it later.
All.
Page 14, why these 3 years of cohabitation, my lord, and why thereafter, my lord, a divorce. I'll answer, but they have answered to me. They have shown it to me. Me means the governor. The governor is given why we have been together, and now what are why it's now or never situation. My lord. That I'll kindly, my lord, allow me to place it at page 14, my lord. Now, your lordships, my lord, kindly take these propositions, my lord, and that would, my lord, perhaps answer your lordship's questions. Because otherwise, my lord, I may not be able to fulfill my promise of, my lord, concluding in.
No, you're right, absolutely. I took some time out on asking.
No.
You're right, absolutely. No.
As,
But it's just that sometimes, you.
just, Lord, on a lighter
just
side,
get- No,
when the
absolutely.
court is quiet, my lord, as I said, the arguments are longer. And my lord, just since everything is, my lord, now very, very serious, and I want to start the new point not on that serious note,
Let's see that.
kindly allow me to use, my lord, one, my lord, kindly So before your lordship takes the proposition. Before your lordship takes the proposition, my lord, on a little light note, I'll start. But there is a Urdu couplet, Mr. Sibal is fond of, my lord, both of us share that. There is a very good Urdu couplet on the situation which is arising. मैं चुप रहा तो और गलत फहमियां बढ़ी. This for the court. When the court is quiet, then we don't understand what is passing in the court's mind. मैं चुप रहा तो और गलत फहमियां बढ़ी. वो भी सुना है उसने जो मैंने कहा नहीं. So this is
उसने जो मैंने कहा नहीं.
वो भी सुना है उसने जो मैंने कहा नहीं. मैं चुप रहा था. So when your lordships are quiet, we understand that there are 10 points.
पर वो भी सुना जो मैंने कहा नहीं. What we in legal parlance call reading between the lines.
But those who write shares, they don't write for legal documentation. They write for some particular person. They write for one individual. That one individual is relevant for them, those who write.
By the way, who is the author of the couplet, Iqbal, or who is it?
No, this is Wasim Barelvi.
Oh.
Very fine. One of the top ranking alive poet who is alive. Contemporary Urdu.
By the way, Mr. Sibal, I don't know if Mr. Tushar Mehta, whether you've read this book called Dilli or Dilli, which is written by one of our lawyers.
Yes.
Supreme Court Bar.
Yes.
Beautiful book.
Beautiful, yes.
On a variety of Urdu poets.
Yes, Delhi had that tradition. Now it's dying. Unfortunately, the best tradition was in Lucknow. Lucknow also, I asked people that there's a dying tradition. In Allahabad also, Firaq Gorakhpuri and all, my lord. Now that tradition is fading away. I'll not say dying, but it's fading away, my lord. It's not. But there are young, my lord, writers.
It's an issue of language, my lord. Actually, language is taken over, and Urdu is a dying language as of today. That's the reality, and therefore we are losing a lot of that culture. That's what it is.
Yes.
You'd like to go through your propositions?
Yes, my lord. Kindly, my lord, come
go through your propositions, so then we are done. We just
Lord,
then look at
para 4,
judgments.
para 4, my lord. Para 4. Lord, page 1, para 1, my lord. In a parliamentary democracy, the cabinet and the chief minister must enjoy and must continue to enjoy the majority support of the house at any given point of time. It is the constitutional obligation of the governor to ensure that government is stable and the government as well as chief minister enjoys majority support in the house. The argument, my lord, third, right now your lordships may ignore, I'll come to it a little later. 4, the question as to whether the government or chief minister has lost confidence or support of the house is not to be decided by the governor and shall have to be decided on the floor of the house. The governor, based upon the material from wherever derived, well, this expression I have borrowed from Bomai, from wherever derived, because this was an expression used by the committee of governors appointed in 70s, and Bomai has approved that report, my lord, can only arrive at a conclusion that prima facie the cabinet or the chief minister has lost confidence, support of the house, which requires to be tested on the floor of the house. His satisfaction is limited only to the requirement of floor test and not whether A enjoys majority or B enjoys majority. Now, my lord, your lordship's very pertinent question was that if, I'm sorry, my lord, your lordship, sorry, that merely because there is some internal dissatisfaction amongst the party, can the governor take this call or not? Lord, a similar question arose, my lord, in case of Rameshwar Prasad, where the question was that you're permitting somebody to request you to hold a floor test would violate 10th schedule. Because what these people, this group who is expressing no confidence against the chief minister, stand disqualified or will stand disqualified under the 10th schedule. And the question before the court was whether the governor, while taking a decision under say Article 174 and 175, is concerned what will be the effect of their act ultimately in the 10th schedule. I hope I'm able to make myself clear. While taking the decision, I am supposed to be cognizant that what they are doing might be a reason for 10 schedule punishment, a consequence subsequently. Your Lordships, my lord, through a constitution bench says no. My lord, please take, my lord, my lord, 2006, volume 2, SCC, page 1. I'll read only 4 paragraphs on this point. That governor is agnostic to 10 schedule. He has to be satisfied that the confidence is lost prima facie. It needs to be tested on the floor. They may suffer consequence, they may not suffer consequence. That's not the governor for the governor to see. That's what your Lordships have said. Lord, kindly see PDF page 393 in JC volume 1.
There are two important things which the governor has not taken into account, which to my mind were extremely important. One, that insofar as the Congress and the NCP are concerned, there is absolutely no shaking up of there is no internal dissension in either the Congress or the NCP. Congress had 44 members, NCP had 53 members. This is a block of 97. There's absolutely no dissension in either Congress or the NCP. So in the 97 still continues to be a solid block. What is disturbed is, say, out of the 56 that the Shiv Sena had, 34 have expressed
Which brings it down to your Lordships.
So out of the second thing which the governor had to bear in mind is this, that as of this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government. So that's again a circumstance which is totally alien to his consideration. So he can't be oblivious of the fact that in a 3-party coalition, the dissension has taken in one party out of the 3. The other 2 are steadfastly support the coalition, and they are not by any means, sidekicks. They are almost at par. All the 3 are virtually at par, except the Congress, which was a little lower.
May I only make one
lower than the.
May I only make one request? Look, to examine the facts of the case, after, my lord, I show the law. Your Lordships are shown, but some of the paragraphs, some of the law is unfortunately, my lord, not assisted.
2006.
Thereafter also, my lord, why the governor can take that step, even if NCP Congress block is not disturbed? I'll, my lord, answer that. Lord, it is para.
What is the citation, Mr.
Lord, 2006, volume 2, SCC, page 1. Para 85.
Which compilation is it?
The judgment compilation 1. Lord, PDF page 482.
Starts from page 393.
Yes, yes.
To go to 482.
482, Lord. Para 85. I'm reading 85, 161, 164, and 165, which is on this point, my lord. And my lord, kindly bear one factor in mind. My lord, whether the court would have taken the same view which the governor took may not be the test while determining, my lord, the decision taken by the governor. Court may perhaps on the facts arrive at a different conclusion. Lord, 85. Certainly there can be no quarrel with the principle laid down in Quixote case about the evil effects of defections, but the same have no relevance for determination of the point in issue. The stage of preventing members to vote against the declared policies of the political party to which they belong had not reached. If MLAs vote in a manner so as to run the risk of getting disqualified, it is for them to face the legal consequences. That stage had not reached. In fact, the reports of the governor intended to forestall any voting and staking the claim to form the government. Well, this was a case of 356. He sent a report that now dissolve the government. Yes.
The stark distinction so far as Rameshwar is concerned, Rameshwar government was not formed. It was at the initial stage immediately after elections.
Correct.
Where there was no party who got the majority. Instead of waiting for somebody to form a majority, the governor asked for dissolution of the House.
356.
And the reason he has given is that if I spend more time to allow a coalition to be formed, they will cobble up a majority and thereby violate 10th schedule and then create a government. So court said the governor cannot assume that the one of the political parties would go ahead, cobble up majority by coalition. This is a wrong inference that the
Yes.
governor has drawn. But as against Rameshwar Prasad's case, this is a case where the government is subsisting for more than 3.5 years. So that's the distinction between Rameshwar and ours. I'm just
Look,
putting it to you.
facts, yes, but the legal proposition which I would, my lord, place for your lordship's consideration may be the same. The consequence which would, the power of the governor or the exercise of power of the governor at the time of initial formation or subsequent shall have to be the same. That's my respectful submission. Please come to, my lord, now PDF page 520 at para 161. Because I, my lord, with profound respect, do not see any my lord, any reason to not read this ratio for exercise of power under 174 and 175 also. This was also the case where the Supreme Court said you should have called for the floor test. You could not have said that, no, they might incur disqualification. 161, my lord, if your lordships are okay. We are not, your lordships gets it, my lord. We are not impressed with the argument based on a possible disqualification under the 10th schedule if the MLAs belonging to LJP party had supported the claim of so-and-so to form the government. At the stage, it was wholly extraneous to take into consideration that some of the members would incur disqualification if they supported a particular party against the professed stand of the political party to which they belong. The intricate question as to whether the case would fall within the permissible category of a merger or not could not have been taken into consideration, assuming that it did not fall in the permissible arena of merger and the MLAs would earn the risk of disqualification. It is for the MLAs or the appropriate functionary to decide and not the governor to assume disqualification and thereby prevent staking of the claim by recommending dissolution. My lord, your lordships are right. My lord Justice Narasimha are right. Fact situation was 356. But why, my lord, I'm posing a question to myself. This ratio not apply when the governor decides to call for a floor test, which your lordship said is the only test. My lord, further, it is not necessary for us to examine for the present purpose para 4 of the 10th schedule dealing with merger and or deemed merger. In this view of the question sought to be raised, kindly see the last line. It could not have been gone into by the governor for recommending dissolution. My lord, what fell from my lord the Chief Justice would be, my lord, if I put it in the context of this ratio, would be that the governor will have to first form an opinion that these people are working since 3 years. They have a reason to, they have shown the reason to the governor why they are parting ways after 3 years. But can they do it after 3 years? Would it not amount to a split? Would it not amount to disqualification under chapter 10, schedule 10? Now kindly come to, my lord, 162, my lord. The provision of the 10th schedule dealing with defections, those of the RP Act dealing with corrupt practice, electoral offences and disqualification, etc., and are legal safeguards available for ensuring purity of public life in democracy. But insofar as the present case is concerned, this had no relevance at the stage when the dissolution of the assembly was recommended without existence of any material whatsoever. There was no material for the assumption that claim may be staked based on democratic principles, but based on manipulation by breaking political parties. Now kindly come to, my lord, 164 and 165. It is true, does your lordship have that? It is true that, my lord, and kindly, my lord, for my satisfaction, read it as 174, 175 instead of 356. It is true, as has been repeatedly opined in various reports and by various constitutional experts, that defections have been a bane of Indian democracy. But at the same time, it is to be remembered that defections have to be dealt with in the manner permissible in law. If the political party, with the support of other political party or other MLAs, stakes claim to form a government and satisfies the governor about its majority to form a stable government, The governor cannot refuse formation of the government and override the majority claim because of his subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. The governor is not an autocratic political ombudsman. If such a power is vested in the governor and or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power under Article 356. The remedy for corruption or similar ills and evils lies elsewhere and not in Article 356(1). In the same vein, it has to be held that the power under the 10th schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10th schedule is of judicial nature, dealing with the question whether power of disqualification of members of the House vests exclusively within the House to the exclusion of the judiciary, which is in Britain was based on certain practices of the British legislature as far as India is concerned. My lord, it has been said, I'll skip that. My lord, please see 166. The governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there would be violation of the 10th schedule and use it as a reason for recommending dissolution. But he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I
see,
earnestly request.
But we are, since beyond those two paras, just those two paras, no such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about, the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance, it is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there'd be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal differentiation is. Therefore, he cannot now say that this 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the House? Prima facie, at least, for him.
Now, let me show the judgment of the High Court, which was dealt with by Bomai judgment. Your Lordship's, my Lord, very right concern, my Lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your Lordship in Bomai did not accept that rejection. Kindly, my Lord, allow me to place, my Lord, that High Court judgment, my Lord. Because when we cite Bomai, my Lord, we generally don't see the High Court judgment, my Lord. Kindly see, my Lord, para 32. And this would be, my Lord, an answer. And, my Lord, please, again, my Lord, I am requesting, please examine the law as agnostic of the facts right now. And thereafter, my Lord, I will assist your Lordship on the facts. What is the law? What is the power of the governor? What are the contours of power? What are the limitations? Lord, please come to para 32 at 2472. My Lord, the right hand side top is the pagination.
1 minute.
2472, my Lord, para 32. So this can be, my Lord, my answer.
Para 32.
32, my Lord, at page 2472 of this judgment. Lord, left or right hand side top, my Lord, is pagination. May I read, my Lord? Yes, I've got. Mr. Soli Sorabji also contended, this is his argument before the High Court, my Lord, that the factors like alleged unethical methods adopted during the formation of Janata Dal, expansion of cabinet, horse trading, and atmosphere getting vitiated are not only vague but have no rational nexus at all. The question of failure of constitutional machinery. The Learned Council also laid, my lord, kindly come down, my lord. Anti-defection law, my lord, it says, I'll just read fully. The Learned Council also laid great stress by contending that governor, by acting upon the letters given by 19 legislators, had circumvented the anti-defection legislation, the primary aim of which is to discourage the toppling game by legislators by changing their loyalties, and by acting upon those letters, the legislators were permitted, in substance, to play the game of toppling the ruling party, ruling ministry, without incurring the consequence of anti-defection law, because if these legislators had withdrawn their support in the House and voted against the ministry, they would have incurred disqualification under anti-defection law. Reliance upon these letters is contrary to the underlying purpose and the essence of anti-defection legislation, and therefore illegitimate and prohibited. Kindly mark this. The Learned Council buttressed these arguments by contending that if the floor test had been held, the legislators would have written letters, who had written letters might have changed their mind for several valid reasons, i.e., change of the style of functioning of leadership, change in the leadership, realization for maintaining party unity, unwillingness to incur disqualification under anti-defection legislation, and 5, not giving a pretext for imposition of precedence rule. In support of the contention that the floor test has always been recognized as the legitimate and relevant method, Sri Sorabji relied on the judgment of Orissa High Court, so and so, so and so. Lord, he was insisting that please allow floor test, because that's what the law says is the only test. That's what we call dance of democracy, is on the floor of the House, not outside. And the governor cannot go beyond a particular point. Lord, this was rejected by the High Court, my lord, at para 54. Sorry, 34. Page 2475. May I read, my lords? Mr. Sole Sorabji had made pointed reference to the 10th schedule, that is anti-defection law, for bringing home this point, that the factum of the withdrawal of support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in
34.
I'm sorry, my lord, page 2475, para 34. My lord, I'll read again, my lord, for my Lord Justice assistance. Mr. Sorabji had made pointed reference. This is the finding of the High Court. Pointed reference to the 10th schedule, i.e. anti-defection law, for the bringing home his point that factum of withdrawal of the support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in the context of anti-defection legislation, floor test was the most relevant, legitimate and surest method to determine whether the Council of Ministers headed by Sri Bomai commanded the majority in the House or not. We are afraid we are unable to agree with this submission of the Learned Council. The introduction of 10th schedule in the Constitution has not in any way affected the exercise of powers under Article 356, nor has it amended Article 356 in any manner. The amending body which inserted the 10th schedule to the Constitution had before it the several decisions, especially the Rajasthan case, as to the scope of Article 356. There is a presumption that the lawmaking body was aware of the existing interpretation, and the court said that no, he should have kept Schedule 10 in mind while exercising powers under 356. Now, my lord, please see how Bomai judgment deals with this. My lord, it was pointed out that para 397, my lord, was read out of context, my lord, to show. My lord, kindly see, my lord, Bomai is, my lord, JC volume 2, PDF page 516. Yes, my lord. Your lordships, my lord, in the judgment of Justice Jivan Reddy, my lord, at page 516, my lord, para 389, formulates the question. Volume 2. I'm sorry, my lord, my allotted time is over, my lord. Kindly allow me, my lord. I'm not repeating anything, my lord, and
Certainly.
the 389, my lord, your lordship says, I'm not reading all questions because they are not relevant for the present. Only question number 6. A special bench of 3 judges of High Court heard the writ petition and dismissed the same on the following reasoning. Please come to 6, my lord. The introduction of 10th schedule of the Constitution has not affected in any manner the content of power under Article 356. Lord, the argument of Mr. Sorabji was that, all right, why you are not concerned with 10th schedule. Direct floor test to be held. Don't dismiss the government under 356 straightway. And, my lord, the court, my lord, thereafter records, my lord, page, my lord, 393, my lord. I'm sorry, my lord, 397. In this context, my lord, the court examined this, my lord, that it is wrong. The governor should consider before removing the ministry, before not installing the government and imposing precedence rule, you should have given the floor test. And that in that context, my lord, 397. Please see, my lord, 397. May I read? We are equally of the opinion that High Court was in error in holding that enactment or addition of 10th schedule to the Constitution has not made difference. The object of 10th schedule is to prevent and discourage floor crossing and defections, which at one time assumed alarming proportions. Whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in case of split, a legislator had to support his party willy-nilly. This is the difference between the position obtaining prior to and after 10th schedule. Prior to the said amendment, the legislator could shift the loyalty from one party to the other any number of times without imperiling his membership of the House. It was as if he had property in the office. That, my lord, in that context, the request was that give me floor test. Don't impose precedence rule. Let the 10th schedule play its role. If somebody votes against the will of the party, he will be disqualified. But don't take extreme step of 156. Take step under 174 and 175. That's what precisely the governor has done. And, my lord, a similar situation arose. And, my lord, now I will read your lordship's the judgment in Shivraj Singh Chauhan, where all this is considered. But before that, please come to para 7 of my propositions. There are more than one reasons, my lord. Why, my lord, this cannot be the argument of the petitioner, and I'll demonstrate, my lord, what is the flip side of this argument. If your lordship, my lord, were to hold that governor cannot examine the inter se dispute, or he waits till the speaker decides disqualification, what is the flip side? I must, my lord, assist your lordship with that flip side. Para 7. There is one more reason why governor cannot preempt the decision of the speaker at the stage of directing floor test, since it is possible that the original political party of the members of the House may condone the defiance of the whip as contemplated under para 2(1)(b) of the 10th schedule. Lord, kindly pause here for a minute. Lord, disqualification is not automatic. If I, as a member of legislative assembly of a particular party, vote in defiance of the whip, so there is a provision that the party may condone it within 15 days. So governor cannot say that I'll wait for 15 days when he is presented with the facts that this is the dissatisfaction. The government has lost majority. There are attacks taking place. There is vandalism taking place, threats being administered. Then I'll not wait for 15 days. because
But
party may.
Mr. Solicitor, there
The
are two
lordships are
distinct,
examining propositions.
they're right. There are two different distinct things. One is a dissatisfaction within a party, right? And the other is a loss of majority of the government. One is not necessarily indicative of the other.
Correct. The
Now
lordship-
tell us, in this situation which we had over here, we now put ourselves in the shoes of the governor. What was it that would have led the governor to come to the conclusion that the government had lost the majority? What was the factual basis for him to conclude?
Again, but only but one thing. But kindly bear one.
Only one 34.
Who were part of the government, who were supposed to be having confidence of the chief minister.
Right. So what
Second,
is
second,
so
second,
therefore
Malord,
now
and the-
let's go to the bottom of it.
Look, can I
Governor-
first take the
govern-
lordships to the
Right.
bottom?
What is the governor saying? What is the governor saying? These 34 who are part of the Shiv Sena have now expressed their dissatisfaction with the leadership of the Shiv Sena. Unless the governor says that the natural corollary is that these 34 will cease to support the Shiv Sena
I'm sorry.
sorry,
Not even that.
not even that. We will make every assumption in favor of the governor's decision. Because that's how we test the proposition. What could the governor have said, though he doesn't say that these 34 persons who are part of the alliance between the Sena, the Congress and the NCP have now expressed their dissatisfaction. He can call for a floor test if he has any circumstances before him to indicate that the strength of this three-party coalition has been substantially reduced. Boma is absolutely correct, it binds us anyway, that this disqualification issue under the 10th schedule is completely irrelevant. But what is the consequence? The governor has to treat these as continuing members of the Shiv Sena. Even before us, they are not saying that we have ceased to be members of Shiv Sena.
Yes.
Now, if they continue to be members of the Shiv Sena, and the Shiv Sena therefore continues to have 55 or 56 members, which it
And
originally
if
had.
they vote against, they will incur disqualification. Governor would say that.
Right. But then where is the question? What is the reason for calling a trust vote?
Because they said
The
that even-
governor, all our judgments say, Rameshwar Prasad says that, Bomai says that the 10th schedule disqualification is irrelevant to the exercise of judgment by the governor.
I am
because
obliged.
that authority
That's
goes
all
to
I'm-
the speaker. Therefore, the facts as they stand before the governor indicate that these 34 are part of the group of 56 Shiv Sena MLAs. Now, if that is so, on what cogent material does the governor call for a floor test? What has changed
Can I-
for him to call for a floor
the
test?
difficulty is,
Tell us one
Lord,
reason
your
why he has to call for a floor test then.
my lord, your lordships are again on facts, my lord. I'm on propositions first. And then, my lord, I'll try and fit into the propositions to the facts of the case. Number one. Number two, principally,
Forget the facts. Forget the facts.
principally,
Forget the facts.
What?
The governor, as a matter of principle now, Bomai tells us and Rameshwar Prasad tells us that circumstances which would lead to the which would warrant the invocation of the 10th schedule are alien to the mind of the governor when he calls for a floor test.
Correct.
All right. So therefore, the possibility that these 34 in our case would incur a disqualification is irrelevant to the exercise of power by the
I
governor.
bow down, my lord.
Right? Now, if that is so, then the governor must forget the facts of this case, the prime principle. The governor must proceed on the basis of the position as it obtains. When the government has been formed, there is nothing which has, unless there is something, some subsequent event which alters the legal constitution of the government, the governor must continue to have before him and analyze the situation on the basis of the situation as it was when the government was formed and prior to the 21st of June in our case. He can't go into the 10th schedule, that's the speaker's jurisdiction. If he can't go into the speaker's jurisdiction, which is the 10th schedule, then what is the basis for calling a floor test? The only reason why he could have called for a floor test is that these 34 numbers These
Number-
34 have alienated themselves. They have given up. They say that we have lost faith in Uddhav Thackeray, and therefore these 34 are excluded, the numbers.
But there
But-
also,
Ah,
but there also, Mr. Solicitor, there's one difficulty for them, and we are only looking at the material that is available for the governor to draw an inference that floor test is necessary. We are not about the facts of the case. Three factors you have indicated. One is the 21st of June letter. Second is the case of threats. Third is about BJP's, and fourth is about the independence letters. Those two, if we eschew from consideration, because from the opposition side, for him to base his decision, apart from threats, which is purely a law and order situation, what is remaining is the 21st,
It's not a law.
of
I'm
June,
sorry.
21st of June 2022 letter. That letter merely informs the governor that we reaffirm that Shinde to be appointed and continues to be appointed as the leader of the house. Number one. Number two, Gogawale will be the whip. You continue to recognize that. Nothing more than that.
Then
It doesn't say anything more than
allow-
that letter.
Allow me to, my lord,
So
answer.
now where does he draw an inference on the basis of this letter,
Yes.
which will become part of the
Please,
material
please.
for him to take consideration?
Lord, please come to, my lord, page 14 of the material, my lord, which I have placed on record, my lord. It's not just a letter, it is coupled with
yeah, we've seen that.
That
a
letter.
resolution. Coupled with a resolution. And my lord, kindly bear one
Resolution
factor.
of the 34, right?
34, my lord. It's not read before your lordship. My lord.
Okay, just
Yeah.
1 second. Let's go to that.
It's a PDF page 14, my lord.
That is at
401.
14.
list of LOD of the governor. No, that's what.
LOD of the governor. Yes.
Yes.
No, that is that's what I was referring to, correct?
That's not what page.
40.
Page
14.
14.
Yes, 40. That letter, that resolution.
Right.
We, your lordship, sir.
Just C17.
Yeah. 17.
The following members of the 14th Maharashtra Legislative Assembly belonging to Shiv Sena. We are notified as the members of Maharashtra Legislative Assembly as members of so-and-so. We had unanimously elected Mr. Shinde on so-and-so as group leader. There was pre-poll alliance between Bharatiya Janata Party and Shiv Sena Party. There has been great dissatisfaction prevalent amongst the members of our party, that is Shiv Sena of our party cadre at large, on account of corruption in the government. Why this 3 years cohabitation and then, my lord, an attempt for divorce, using, my lord, that sort of expression. Administration regarding police posting, corruption by the then Home Minister Sri so-and-so and sitting Minister Sri so-and-so, who is also in jail for involvement with underworld Don Dawood. Apart from above reasons, our party cadre faced tremendous harassment and distress on political as well as personal grounds from the opposition ideological parties who are not now a part of the government and were using their office and power to undermine the base and foundation of our Shiv Sena cadre. This is their reason. I am not justifying, nor can I put myself into the shoes of the governor. And with profound respect, your lordships would also examine not what your lordships would have decided with these facts, but whether there
No, but
exists.
what the governor can constitutionally decide. We are not going to go into whether what our view is the situation.
Kindly allow me to complete the sentence.
Constitutional duty and power of the governor. in
Lord,
this
Can I
situation.
only complete the sentence?
And see page 17 now, PDF page 17.
Lord,
Hence, it
Lord,
is
kindly
unanimously,
allow
the
me to
end of
read.
it, what do they
15.
say?
Lord, I'm on 15. Can you
Okay,
allow me to
15,
read?
yes.
15 also? This is enormous discontent. There is enormous discontent amongst the cadre of our party, that is Shiv Sena, for forming the government with NCP and Indian National Congress, who are ideologically opposed to our party, that is Shiv Sena. Initially, they say that they are destroying our cadre base. They are corrupt, found to be corrupt in near past. We are facing embarrassment. Then they say there had been a compromise on the principles of our party, Shiv Sena, which had been a party with fierce ideological base and was formed for fighting of the rights of local Marathi people. For last 2.5 years, our party and its leadership has compromised party principles by aligning with the contrasting ideologies for the sake of achieving power in the state of Maharashtra. The ideology of our party's leader, late Shri Balasaheb Thackeray, was to give clean and honest government to the people of Maharashtra, and also without compromising on the principle of so-and-so, which was defeated at the first day itself by aligning with the opposition ideologies. Shiv Sena and Bharatiya Janata Party had forged a pre-poll alliance for 2019 Maharashtra Assembly elections. They sought the blessings of voters for this Shiv Sena BJP alliance, which the voters accepted and voted in favor of this alliance. After the results were out, the Sena severed its ties with BJP and formed an alliance with opposing parties which they fought against in the 2019 assembly elections. This act of our party leaders had a tremendous negative impact upon the voters and the party cadre at large. As an elected member, I am answerable first to my voters, then to anybody else, my lord. Because 39 members can say that we will vote against the party even at the cost of being disqualified and ceasing to be MLAs. Then the governor is faced with a situation where there would be unstable government which cannot withstand on its
Which means he's going to the disqualification issue.
No, I'm
potentially.
sorry.
That's the problem.
That 39
Right. All that you are reading up to PDF page 17, where they passed the resolution. The resolution is at page 17. Huh? There are two parts of this letter, two parts of the resolution. First part is, let's formulate it. One, the first part is BJP and Sena had a pre-poll alliance. One. In breach of the pre-poll alliance, the Shiv Sena teamed up with the Indian National Congress and the NCP. Two. Three. By teaming up with the NCP and the Indian National Congress, the Shiv Sena has militated against the core ideology of the Shiv Sena. Four, that there has been corruption in the government. And five, that there is discontent within the cadre of the party. This by itself will not justify the governor in calling a trust vote. Never. That's what our judgments have repeatedly said.
No, your lordships have said otherwise in Shivraj Singh Chauhan.
The fact that the conduct of a government has gone against the core ideology of that party can never call for a trust vote.
But I'm sorry.
Now, what then is in that letter? What then comes in the resolution? Two things. That we reaffirm that Eknath Shinde, who was elected as the leader of the party, continues to be the leader. And two, that Gogole, that we reaffirm that Gogole is elected as the chief whip. Two things. The first part of the resolution has no bearing on a trust vote at all. The first part of it only reflects on the fact that there's grave disquiet among these people that, well, you militated against our pre-poll allowance and the core ideology of the Shiv Sena. That's alien to the governor because they've formed government already. Second, what do? They merely reiterate that Eknath Shinde continues to be the leader of the party in the legislative party. How is this a justification for a trust vote?
I'll just
Change in the chief
answer
whip.
that question. Well, kindly come to page 21. PDF page 21. This is signed by 41 MLAs. My lord, the difficulty is, my lord, we are trying to examine and analyze the justification given by 34 or 39, whether it could have been a justification for floor test. For governor, he has to only examine that, but for this 39, the government would fall. I would rather go for the floor test.
In which case, he is now saying, assuming. No, but
They are
you're
part of the
right.
company.
You're absolutely right. You're spot on. There's no difficulty about it at all. Therefore, what the governor is saying is, but for these 39, as you rightly say, the government will fall. Can he look into the fact that but for these 39, the government will fall when exclusion of these 39 is postulated on the speaker passing an order for their disqualification under the 10th schedule. Until that order is passed, he cannot presume that they are going to be.
He is not.
It's a preemptory move.
But I think we are.
To say that we remain part of that.
Correct.
government.
Exactly.
We are not parting company.
My lords are saying the same. My lords.
They say that we continue to be in the Shiv Sena.
Correct, my lord. But still, we don't
They
support the
continue to
government.
be in the Shiv Sena. Then how do you call for a trust vote?
Or what is the apprehension
Lord,
that the government
Trust
has?
vote is not against Shiv Sena. Trust vote is against the government, against the chief minister. Lord, suppose what happens if the leader loses the confidence while members remain. Lord, now kindly see, my lord, kindly see the flip side of this. Flip side is this. Lord, today there is a government of Shiv Sena and BJP. Now, your lordship's, my lord, prima facie view is that merely because some people go and say that we don't trust this government, governor should not do anything, not that cannot do anything. Your lordship's prima facie view is, this is debate, my lord. I hope this is not the conclusion. Your lordships are only,
In a
Exchanging.
dialogue.
yes, it's a dialogue. Now, suppose today BJP has what, 106 members. Lord, 100 members were to say that we have lost faith in the leader. Even our chief minister, kindly allow,
Right.
kindly allow me to,
So 106 say we have lost faith in Fadnavis. Okay.
kindly,
He was a
allow
leader.
me to,
For a moment, postulate it. Yes, you're right. Absolutely. Exactly. You're absolutely on spot on.
kindly see, my lord. Would your lordships consider giving governor the power to wait for the floor test and ensure that there is some management where the majority is created? That's the flip side of it.
Mr. Solicitor, you can never allow the governor to ask for a trust vote when there is absolutely nothing to shake the majority on the floor of the House. What is the trust vote for? Do you have the numbers in the House? The trust vote is not for determining who is going to be your leader in the House. No. The trust vote, what is the purpose of the trust vote? In a House of 288, do you have 144? That's the purpose. And if there is nothing to indicate that 144 is disturbed,
That is,
who will lead those 144 is alien to the governor. It may not have been Uddhav Thackeray. They could have elected somebody else. The INC, NCP, and the Sena would have, and the Sena would have said, "Okay, we're electing somebody else."
would your lordships come to page 21? There is a
But
direct.
that is a matter of internal party discipline. You see, that can never be a matter for the governor. Governor's trust vote is where the majority in the House is shaken. And where was there anything to indicate that this?
Page 21. Page 21.
Yes,
Yes.
page 21.
Page 21.
Yeah.
And
This
it's
is
see,
47 MLAs writing to the governor on 25th of June, para 2.
25th of?
As is common knowledge, we no longer wanted to be a part of the corrupt MBA government. However, we were being continuously threatened to continue supporting the incumbent government without our free will. Thus, left with no option, we were constrained to flee away, said so and so. However, as yet another attempt to break out our resolve and arm twist us to give into the demands of MBA government comprising NCP and INC goons, security which was earlier provided, etc., etc. They say we don't wish to support this government, meaning
no, Mr. Mehta,
thereby-
if you will look at para 11, that's the conclusion. We demand security. That's all. They don't say we are parting company. Where do they say that?
My
They
lord,
say, please give us adequate security as also our
Lord,
family because it's
my
been
lord, the
withdrawn.
governor is not, my lord, a court where this prayer was not couched in this manner. He has to, based upon the material before him,
No, no,
arrive.
Mr. Mehta, what is being pointed out? What is being pointed out it is this communication cannot be said to be withdrawing the support to Mr. Uddhav Thackeray.
Lord,
This is that what happened earlier,
what it
what happened
says.
that.
What it says, but it may say that give us protection, but they say we no longer want to be a part of this corrupt government.
Correct,
Meaning
but
thereby
they-
47
then-
people are minus now
And they
from the
don't say
magical mark.
what is being pointed out, then thereafter they don't say further that henceforth, correct, we are not supporting this.
If it
we are
is a
withdrawing
petition, there is no
and
prayer.
therefore the subjective satisfaction.
What's the next step they took after they said we are no longer
They-
want to be part of the
continued.
corrupt
All
government?
right, you can just reflect on it.